Virginia has just rewritten the record books in one legislative session. In 2026, the Virginia General Assembly enacted 10 sweeping new firearms regulations. Regulations so comprehensive that they will transform the everyday reality of nearly every gun owner in the Commonwealth, effective immediately. To grasp why this matters so much, there's one critical fact you need to know. For years, legislation just like this kept dying in committee or facing gubernatorial vetoes before ever reaching the statute books. But in 2026, Democrats control 64 of 100 seats in the General Assembly. And for the first time in recent memory, they also hold the governor's mansion. That is complete control of state government. And they exercised that power before the crossover deadline alone. More than 25 firearms regulation bills remained active and progressing through the legislative pipeline simultaneously, something Virginia has never witnessed before in a single session. Some of these measures affect how you secure your weapon at home. Some alter who can legally acquire one, and one of them prohibits an entire class of firearms that millions of Virginians currently possess. What is even more remarkable is that Virginia now belongs to a select group of states that have succeeded in passing this volume of firearms legislation in one sitting. Most states require years to advance even 2 or 3 bills simultaneously. This is not gradual evolution. This is a total transformation occurring all at once. And if you reside in Virginia, it is already impacting you whether you realize it or not. Now let's examine the legislation itself. And we're beginning with the most significant measure first. House Bill 217 represents Virginia's newly enacted assault weapons prohibition. And here is precisely what it entails. If you did not already possess one of these firearms prior to July 1, 2026, you cannot acquire one, import one, or commission one to be manufactured ever again within this Commonwealth. However, if you legally possessed one before that cutoff date, you retain the right to keep it. That is what is known as a grandfather provision. Additionally, the same statute reduces magazine capacity to 15 rounds maximum, meaning any magazine containing more than 15 cartridges cannot be sold or transferred in Virginia going forward. Now here is where the impact expands further. A Senate Bill 643 elevates the minimum age to acquire a handgun or certain semi-automatic rifles from 18 all the way to 21. That means, currently in Virginia, an 18-year-old can legally serve this nation in combat, but can no longer legally purchase a handgun in their own home state. These 3 modifications alone impact an estimated 8.9 million residents living in Virginia today across the nation. Only a limited number of states have a comparable combination of an assault weapons prohibition, a magazine restriction, and an elevated purchase age, all operational simultaneously. And Virginia just entered that roster overnight. For firearms retailers across the Commonwealth, this also means their complete inventory and sales procedures must be reviewed and modified immediately, or they risk violating the law themselves. These subsequent modifications are not about which firearm you possess. They are about how you handle it every single day. Under House Bill 110, if you leave a firearm unsecured inside your vehicle and someone observes it or accesses it, you are now facing fines, your vehicle being impounded, or even a misdemeanor charge on your record. This is not a caution. This is a statute with genuine penalties attached to it, and it does not end there. Senate Bill 348 now mandates that gun owners secure their firearms safely inside their residences. And in some iterations of this measure, that means a biometric locking mechanism is the sole storage method that qualifies as lawful. If a minor gains access to an unsecured weapon in your residence, the criminal liability rests squarely on you as the owner. Virginia currently has approximately 3 million registered gun owners, and every single one of them must now reconsider how they secure and transport their firearm on a daily basis. These are not headline-grabbing prohibitions. These are the subtle regulations that catch people most off guard. Research has demonstrated that over 4.6 million American minors reside in homes where firearms are kept loaded and unsecured, and Virginia legislators cited that figure directly when advancing these storage measures through. What makes these regulations even more consequential is that a first-time infraction could remain on a gun owner's permanent record, impacting future acquisitions, employment background screenings, and even their right to possess firearms. Moving forward, these statutes are not going to fade away quietly, and the legal battle has already commenced before most of them even take effect. Gun Owners of America, one of the nation's largest gun rights organizations with millions of members members across the country, has already announced that their legal foundation is preparing to sue the Commonwealth of Virginia directly over these new statutes. Their position is straightforward. Several of these bills, particularly the assault weapons prohibition, violate rights that the United States Supreme Court has already affirmed and safeguarded in 2022. The Supreme Court delivered a landmark opinion known as the Bruin decision, which made it substantially more difficult for states to restrict how and where Americans can carry and possess firearms. Republican legislators within Virginia's own General Assembly referenced that exact opinion during the floor debates, warning that these statutes would not withstand judicial scrutiny. Additionally, the National Rifle Association has also urged gun owners to contact Governor Spanberger directly and request a veto before these bills are enacted. What makes this conflict particularly significant is that whatever the courts decide, Virginia's case could establish precedent that influences firearms laws in every other state across the nation as well. It is also worth observing that comparable assault weapons prohibitions in other states have already endured years of legal challenges. Illinois enacted its own prohibition in 2023, and it continues to be contested in federal courts today. Virginia's case is anticipated to proceed rapidly, given the national attention it has already attracted, and gun rights organizations have made it abundantly clear they possess the legal resources and the funding prepared to contest this all the way to the highest court. And with Governor Spanberger yet to formally enact every bill into law, there remains a brief window where public pressure, legal challenges, and political negotiations could alter the final outcome of at least some of these statutes before they are fully cemented. Not every one of these 10 statutes has an equal probability of surviving judicial review, and legal scholars are already identifying which ones are the most susceptible. The assault weapons prohibition under House Bill 217 is regarded as the most legally vulnerable of all of them, because the Supreme Court's 2022 Bruin opinion specifically held that any firearm commonly possessed by law-abiding Americans is protected under the Second Amendment, and semi-automatic rifles are possessed by tens of millions of people across the nation. The public carry limitations under Senate Bill 727 face a very similar legal challenge for precisely the same reason. Conversely, statutes like the ghost gun serialization requirement and the vehicle storage regulation are considered far less likely to be invalidated, because courts have historically permitted states greater latitude to regulate how firearms are tracked and stored, rather than whether they can be possessed at all if litigation is initiated, which it almost certainly will be. The legal process alone could require anywhere from 1 to 3 years before a final judgment is rendered, meaning these statutes could be enjoined by a judge long before they are ever fully implemented on the ground. To provide a genuine comparison, when Maryland enacted a comparable assault weapons prohibition back in 2013, it required over 4 years of court battles before it was ultimately upheld, and even then, the conflict did not fully cease. Virginia is now traveling down that identical path, and with the current composition of the Supreme Court leaning more conservative than it did in 2013, the outcome this time could be substantially different. What every Virginia gun owner needs to comprehend right now is that even if a court issues a preliminary injunction against one of these statutes, that does not mean the statute is eliminated. It simply means the conflict advances to the next stage, and in the interim, the remaining statutes remain fully operative and enforceable. If you are a gun owner in Virginia right now, are you relocating to another state, or are you remaining and contesting these statutes in court?